The principle that makes judicial review especially potent in our scheme, a strong form of judicial review, is the second fundamental proposition out of Marbury. And that is that the Constitution is a species of law. It's a kind of law. And it's the province and duty of a court, and ultimately the Supreme Court, to say what the law is, including to say what the Constitution is and what the Constitution means and requires. Now, at issue in Marbury was a section of the Judiciary Act of 1789 that the court read, and the attorneys in that case read, as giving the Supreme Court original jurisdiction in a certain class of case. The court also, however, read Article 3, which creates the Supreme Court and identifies the kind of cases it can hear, including cases it can hear as part of its original jurisdiction. The court read Article 3, the Constitution, as not permitting original jurisdiction in that kind of a case. Thus, the court found a conflict between the Judiciary Act, a piece of legislation, and the requirements of Article 3 under the Constitution. And the court was duty-bound to make this determination because, again, the Constitution is a species of law, and the court had to say what the law meant, what the Constitution meant, what the statute meant. And finding a conflict, it had to declare that the legislation had to give way to the superior commands of the Constitution. Now, judicial review did not have to be as was decided in Marbury. We could have had a lesser form of judicial review. As I've said, we could have had a situation where, although everybody agrees that the Constitution is fundamental law, superior and binding on everybody, still Congress or other actors in the government could have decided for themselves whether their acts were or were not consistent with the Constitution. But we didn't do that. We also didn't limit Marbury to a decision where judicial review could be exercised only in a kind of a case that involved the jurisdiction or the proper jurisdiction of the courts, as Marbury did. We have no basis for confining Marbury that way, and we haven't confined it that way. In fact, in a case you may look at in your text, the case of Cooper versus Aaron in the 20th century, the court said that the federal judiciary is supreme in the exposition of the law of the Constitution. So we do have a strong form of judicial review, and the court's interpretation of what the Constitution requires binds all governmental actors. It binds the federal actors, the Congress, the President, regulatory agencies, and it binds all state and local government actors as well. Indeed, in terms of binding state and local governments, it's probably the case that judicial review and a strong form of judicial review is even more strongly based than review of what Congress does as a coordinate branch. Now, with respect to the Supreme Court's review authority over states and their actions, and particularly over state court cases that involve issues of federal law, consider the case of Martin versus Hunter's lessee, a case that was decided shortly after Marbury. In that case, the court had to consider whether it could review a constitutional judgment of a state court. What was happening there was the state courts had jurisdiction and decided a case about who owned certain land. And one party was claiming under the law of the state, and the other party was claiming under a federal treaty. And the state courts decided that the federal treaty did not control. They interpreted the treaty according to their best judgment and decided the case under state law, thinking that the federal treaty didn't control. But when the case went to the Supreme Court said the treaty does control and ordered that judgment be entered for the alternative party. Well, when the Supreme Court sent that back to the Virginia courts to implement its ruling on the treaty, the Virginia court said, wait a minute, you have no review authority over us. You can't tell us what to do. We had the case and we decided it, and that's the end of it. But in Martin versus Hunter's lessee, the court said, yes, we do have review authority over you. First of all, there's a very strong textual argument that the Supreme Court has review authority over state court cases involving federal law, because if state courts have the authority to decide federal constitutional claims, and they do, and if Article 3 gives the Supreme Court jurisdiction over all cases arising under the Constitution, which it does, then by definition, the Supreme Court can decide constitutional cases no matter where they come from, whether they come from the federal system or the state court system, and that's what the court decided. There's also a strong argument in favor of Supreme Court review of state court judgments involving federal law, arising out of contemporary understanding. The Congress assumed that there was such review authority, and in the Judiciary Act of 1789 it was specifically provided for. And finally, as if this weren't enough, there's also a strong policy argument about why the federal courts ought to be able to review state court judgments involving matters of federal law, and that is the uniformity of federal constitutional law. If states could decide federal constitutional issues, and if they were not subject to review by the Supreme Court of the United States, you could have this very untenable situation where the federal Constitution could mean 50 different things in 50 different states. So, there is the power of judicial review. It's a potent power. It binds all actors in the government, including state and local actors, and including review of state court judgments that involve matters of federal or constitutional law. Now, judicial review is, as I mentioned, the centerpiece of constitutional law. It's not going to be changed. It's not going to be overruled. However, there are fundamental questions about how judicial review ought to be exercised. And there are differing views, radically differing views, about how the court ought to go about its business when deciding constitutional cases. Just as a general orientation, there are those on the one hand who view the court's role as appropriately activist. They would say, for example, that the court is functionally best positioned to be the expounder of constitutional principles because the court is, after all, insulated from the political process. As you know, justices of the Supreme Court have lifetime tenure, and the nature of what they do really exalts reason over expediency. They are, as some have said, the organs of sober second thought in our scheme. And those viewing the court from this perspective believe that the court should act affirmatively and be active and determine issues of constitutional law when they are presented. Some part of the government must ensure fidelity to the Constitution and the protection of individual liberties. And from this perspective, the court shouldn't shy away from that role, and the court is good at it, so it should do it. Now, on the other hand, as an alternative vision, some see a far more restrained role for the court. For them, the court should act using the power of judicial review only when it absolutely has to, when there's an obvious conflict between a government act and a constitutional provision. And even then, the court should only act as narrowly as possible. This vision stresses that the insulation of judges is actually a liability, not a plus. That is, because courts are not elected, it's illegitimate for them to make broad-based decisions in a democratic scheme. They aren't elected, they are insulated. It's better that most of the judgments that govern what the society does be made by the legislative process, by democratic majorities. The court is counter-majoritarian. And so from this perspective, judicial review is almost a necessary evil. Courts shouldn't reach out to decide cases, and they should be very, very sparing in their use of judicial review. So, at the outset of our discussions about constitutional law, here's a fundamental point to keep in mind when studying constitutional law. Every time the Supreme Court decides a constitutional question, it's not just deciding what the Constitution means. It's also deciding what its appropriate role is in the society and in our system of government. And over again, in a variety of ways, as we go through these materials, you'll see that the court's concern about its proper role plays as much a part, sometimes, as the actual constitutional provisions themselves in how a court decides a case. For example, The court is fully aware of